Ronaldo or Mr. Madeira, whoever's arguing, I will hear you, sir.
Thank you, Your Honor. Your Honor, let me start by thanking the court for allowing me to file that motion being heard this morning. Your Honor, this case is not in total by any means controlled by Commonwealth v. Carter for various reasons. One, we are dealing with a different standard, a heightened standard at this point. In the SJC's decision of Commonwealth v. Carter, the SJC was dealing with the standard of probable cause, enough evidence to arrest. In the evidence has also changed. The evidence was just the evidence presented to the grand jury versus the evidence after the Commonwealth has rested. So there are some significant differences between Commonwealth v. Carter and the SJC's decision and the decision that you need now make. First on the evidence, there is a vast more amount of evidence presented to this court at this juncture than the SJC had. You have had access to more information, video of Conrad. You've had additional documents, written documents, various text messages, photographs, and the like, and the testimony and cross-examination of several witnesses. So the evidence is vastly different. Also, to touch upon the standard, the Lattimore standard, it is no longer probable cause. It is, although taken in the light most favorable to the government, it still must be proof beyond a reasonable doubt to a rational trier of fact. Your Honor, so there are certain things that I understand the court will look to the SJC decision of Carter, but to the extent that that decision made federal decisions of how it interpreted the First Amendment, for instance, is not controlling. The issues of free speech and not having a statute against the criminalization of suicide or assisted suicide or encouraging suicide, that's what the evidence presented shows, that there was an encouragement type situation. So under the First Amendment, we have no physical activity. The evidence has now been closed by the Commonwealth. They've rested. There's no physical actions taken by Ms. Carter. So on this heightened standard of proof beyond a reasonable doubt, although taken in the light most favorable to the government, it is insufficient to let this case go on any further now that the Commonwealth has rested. The elements of manslaughter, Your Honor, recklessness and causation. Let me start with the causation issue. But for the actions of Michelle Carter, Conrad Roy would have not committed suicide. I suggest there is not sufficient evidence. It would be speculation for this court to then allow the case to go further, because the causation issue, there just is insufficient evidence to a reasonable fact finder to say that Conrad Roy would not have taken his own life on July 12th or July 13th of 2014, but for Michelle Carter. There is, you've heard the various testimony, you've reviewed many, I'm sure, a lot of information, and you will continue to do so, in assuming you consider this motion. You will see the history of Mr. Roy. That's what the evidence shows at this juncture, that Mr. Roy was suicidal for a very, very lengthy period of time. That comes out in his text messages very clearly, not just the text messages that were played on the display board, but all the information, including the journals, the exhibits that the court has to consider and review. So I would suggest also on the recklessness prong, Your Honor, the Commonwealth has failed even at this stage, because there is no omission or commission by Ms. Carter. She did not have a duty, a legal duty, and therefore any omission to call for assistance is lacking in the evidence at this point. There is also there is no commission but for speech, and that goes again, but for speech is the only acts, if you will, are her so-called verbal acts, and I'll touch upon that in a minute under the various other issues that I wish the court to consider. And I've laid this all out, as you know, Your Honor, in a written memorandum touching upon all these issues. I would also suggest to the court we are dealing with a decision why the Commonwealth v. Carter decision, again, should not be controlling, is because the Supreme Judicial Court said under common law it had the right to interpret a particular statute or define manslaughter, to the extent, and if you look at the decision, it actually even says it, that it had not previously had a case such as this where there are just words dealing with manslaughter. So its expansion in its announcement of probable cause, in its expansion of the manslaughter definition of common law, as well as the legislature's written statute on manslaughter, to the extent that it's interpreting a statute, then I would suggest to the court it's a violation of ex post facto under the United States Constitution, as well as the state constitution, but in particular under the United States Constitution. Further, to the extent that it is saying it is common law, therefore the court has the ability to do that, I would say it's a fundamental violation of Ms. Carter's due process rights, because even a court cannot retroactively apply a criminal law, even a common law, to a particular defendant. So I would suggest that that would be a violation of Ms. Carter's due process rights, with all due respect to our Supreme Judicial Court. Your Honor, there is also the statute, and I know that the SJC did touch upon this, but the vagueness argument, and I do make that and press that upon this court as well, Your Honor, that it was not clearly defined. And again, we are dealing with speech, and this is not speech that it is speech to commit suicide. Suicide, there is no statute in Massachusetts outlawing suicide. There is no statute in Massachusetts saying it is against the law to assist or help in a suicide. The evidence shows in the text messages Conrad Roy specifically asked Michelle, do you want to help me? So he specifically sought her assistance, her encouragement, Your Honor. That's what the evidence is in the record, in those text messages. Mr. Roy asking, again, not put up on the big board for everyone, but it's in evidence. It's in those text messages. So the evidence has to be looked at, Your Honor, and when you see Mr. Roy asking, reaching out, it goes back to the causation. Did Ms. Carter's, the sufficient evidence at the higher level now of Lattimore to say that she caused Mr. Roy's death, his suicide? Did she actually cause his death? The medical examiner, you heard from her, Your Honor, and the death she ruled was suicide. She did not rule it a homicide. She testified to that. The case has now been closed. That's her testimony, Your Honor. Your Honor, also, I'd like to point out the youthful offender statute. The SJC did not get into great detail on this, and this is either the infliction of serious bodily injury or the threat of serious bodily injury. Under the Virginia Black case, under Virginia Black case, the U.S. Supreme Court said the only words that can amount to a unprotected speech expression would be true threats. The United States Supreme Court, true threats. The evidence now that the government has rested do not amount to true threats. We do not have true threats here. And under the youthful offender, it is up to the fact finder to decide whether or not it has to be under the Apprendi decision in the United States Supreme Court. Is the fact finder is the one to make a determination if there is an infliction of serious bodily harm or a threat. It is insufficient under law to simply say that the statute itself is inherently dangerous. That's insufficient. There must be facts put into the case to determine whether or not a defendant actually committed certain actions that amounted to the infliction. It's insufficient to say the statute dictates that. That's not what Apprendi states, Your Honor. It has to be a fact proven to the fact finder. So under the true threat doctrine, there's been no evidence in the record that Michelle Carter ever threatened Conrad Roy in the text messages. A true threat as a violation of crime, as I will hurt you, I will hurt your family, I will do bad things. That's not in evidence, Your Honor, in any of the text messages whatsoever or any other exhibits that have been put in. In the infliction, we maintain to the only way the statute of the youthful offender statute as well can survive constitutional muster is that there be a physical act, not a words of expression of suicide. That just is insufficient. Also, Your Honor, on the issue I do want to touch upon, on the issue of causation for a moment, there's been much made about Mr. Roy being pressured or being told to do it. You've now had the opportunity, or soon will, to review the exhibits, and you will see Mr. Roy giving a videotape. That's part of the record. This is an individual whose faculties, I think the evidence shows, even taken the light most favorable to the Commonwealth, he has his faculties about him. He knows what he wants to do. You have suicide notes previously written back in 2012 to various people, and you also have a suicide note to Ms. Carter written, I think it was shortly before Mr. Roy took his own life. So from those standpoints, Your Honor, I think the evidence is insufficient to say that she caused him to die. One moment, please, Your Honor. Additionally, what was, and you will see it in the Supreme Judicial Court's decision of Commonwealth v. Carter, is the reasonable juvenile mind. I would suggest we did address that issue. However, they did not address it. They did not say that they would hear it. But at this juncture of a criminal trial, we now also suggest to this court, now that the Commonwealth has closed, that the standard that needs to be proven beyond a reasonable doubt under the Lattimore standard is a reasonable juvenile in Ms. Carter's position would have known about the dangers, not a reasonable adult, which was presented to the grand jury. So there is a claim that we are now pressing to this court that the court has to analyze this motion under that umbrella of a reasonable juvenile standard. And I've laid this out in the memorandum that I have passed into the court. So, Your Honor, again, the evidence, the Commonwealth may be arguing, just look at Commonwealth v. Carter, they've already decided. No, they didn't. They decided probable cause. I think probably one of the lowest standards we have, if not the lowest standard in our criminal law system. We are now dealing with proof beyond a reasonable doubt standard. And I do not think, given the evidence that has been now submitted, significantly more evidence than was presented at the grand jury. And for those reasons, we ask you to allow the motion at this point, Your Honor, on both the manslaughter charge as well as the youthful offender. They're two separate, and if the court isn't going to issue a allowance of the motion on the manslaughter, it's a separate issue on the youthful offender, and we press those same issues that this is speech, you need physical activity, even on the YO. You can't just look at the statute. Thank you.
Thank you very much. Aldo, you would dive into the Commonwealth?
I will.
Rayburn, good morning.
Good morning, Your Honor. Actually, I'm not just going to stand here and say, look at Commonwealth versus Carter and sit down at all, Your Honor. And I do think that the SJC did address some decisions, but I agree with counsel. You have a lot more evidence than they did, and I think it's a lot more evidence in favor of that the Commonwealth can point to, and that I will point to, Your Honor. And I'm really just going to start with the elements of the offense of manslaughter and then move on to youthful offender, if I could. In looking at the elements, Your Honor, I'd suggest to you first the Commonwealth has to prove that the conduct was intentional. Not that the outcome was intentional, but that the conduct was. And I would suggest to you clearly we have that. And the SJC was clear to say, and I suggest to you the case law supports it, that no physical act was required. And it's never been required that you have to be at a scene of a crime. Joint venturers are often convicted and they were never even there, Your Honor. That is a physical requirement. And the fact that counsel reiterates throughout, I only gave it a quick read, but I'm assuming it mirrors some of his prior pleadings that she wasn't there or miles away. Your Honor, that was really insignificant in terms of whether or not she could be culpable. There's no law suggesting she has to be there. But moving on to recklessness, Your Honor, which has both a subjective, as you know, and an objective standard. I would suggest to you the objective standard of it when an ordinary person under the same circumstances realized the gravity of the danger. I would suggest clearly the average person would have known what was going on here could result in substantial bodily injury and possibly death, and it did. So I guess the bigger question here is, has the Commonwealth met a subjective standard? Did this defendant know? And in doing that, Your Honor, I ask that you consider the evidence. Not just what you know about Conrad, but what you learned about the defendant during the course of this. What you learned is that the two of them had a relationship of some sort. And the fact, if I may, Your Honor, the fact that this was a mostly texting relationship, I don't believe diminishes the seriousness of this relationship in the eyes of Mr. Roy or should in the eyes of the court. It's clear that the defendant had a number of what she at least believed to be substantial relationships, mostly through texting. You learn that through listening to the young lady she goes to school with, that was a lot of what she did was texting. And over a period of time, the two of them formed a bond. And when I stand here before you, Your Honor, and last night I read the SJC decision, and I went through the text messages almost sort of for the first time, as though Your Honor might be doing, to read it again to see what I could see. And obviously the ones that I've gone over with the court and the more obvious ones jump to mind. But in looking between the statements of why haven't you done it yet and things of that nature were other words, and they were words of love. She combined words of kill yourself with words of love. And I think that's significant because if you look back to June, Your Honor, her words of love were combined with don't kill yourself. And over time, it's clear that Conrad grew to depend on her and to love her in some way as well. And then you see in July it switches over to words of love and words of killing yourself. And I would suggest to you, although it may seem odd that I'm suggesting that words of love could be considered reckless, I think they are here when you look at the circumstances. And I think that one of the parts of the SJC decision I would like to quote to Your Honor, it says, to ignore the influence the defendant had over the victim would be to oversimplify the circumstances of his death. And I think that's important here, Your Honor, to suggest that he had his own free will, and we all do to an extent, and he could have just ignored her as an oversimplification of what was going on here. For two reasons, Your Honor, and again, I'm talking about the subjective standard. Because she knew him. They had been texting for a long time. She knew how he felt. She knew that he had social anxiety. She knew that he was depressed. She knew his frailties because he confided in her. But not only that, Your Honor, she knew herself. She knew what it was like to be lonely and to want someone to talk to. That was the significance, Your Honor, of some of those young ladies' testimony, not just to go through the text messages or to try to establish some sort of motive to you, to show the defendant's mindset. I ask you to think back to that text message that she wrote to Sam Boardman, talking about how people didn't ask her to go out and how much it meant to her that Sam wanted to be friends with her and how that felt for her. So she knew Conrad, she knew how he felt, she knew he was depressed, and she knew he needed a friend, and she knew what that felt like. And she would know how much her comfort would mean to him. And that as June turned into July, she took that feeling that he felt for her, that she was comforting him and he was relying on her, and she turned that into, I love you, kill yourself. And then she isolated him from his family, saying that they would understand when he died. That is the very definition of recklessness, what she did to him, Your Honor. She knew his frailties, and you can't look at it in a vacuum, Your Honor, just that he, most respectfully, I ask you not to look at it in a vacuum, that she was just saying these words and he could have ignored them because she had this relationship with him. Look at Procedural, I would respectfully suggest, Your Honor, because the court considered the relationship. It wasn't a stranger putting a gun in another stranger's hand. It was a husband and wife relationship. Your Honor, she goes back, 7/6/2014, you are my forever, my home, my hero. That's what she's saying to a depressed boy who is talking about social anxiety, who just wants someone to love him and sort of tell him everything's going to be okay. She even says that. I just had to say that I loved him and he wouldn't have done it. She was reckless, Your Honor, and she caused his death. Look at the causation. Not only do you have the words, I told him to get back in the car, which the SJC calls as the final directive, but you can go back to the text messages that he sent her, that he sent to her. Another day wouldn't hurt. I'm too scared, you're right, I don't have it in me. And this is the big one that I think the SJC focused on the day he died at 9:49 in the morning on the 12th. Like 2 weeks ago, I was willing to try everything, and now I'm worse, really bad, and I'm not following through with it, "It's eating me inside. I'm too messed up." On the 11th, "I'm scared, babe." And he says on as well, "I do not want to, but I'm like freaking out for my family." He is hesitant. And the SJC also focused on the length of time. They're talking about suicide really from the 1st of July until the 12th of July. That's 12 days that he doesn't do it. That they're talking about it all the time, but he doesn't do it. And he's talking about being scared and being hesitant. And it's also reflective, and this is something else the SJC I don't believe knew because they hadn't heard from the medical examiner. That's consistent, you're saying that he was scared, and she told him back in the car, consistent with what the medical examiner said and what the phone records, you had those, Your Honor, in one of the exhibits. Their last call was 46 minutes, thereabouts. Doesn't take 46 minutes to die from carbon monoxide poisoning. It takes 20 minutes, give or take, according to the medical examiner. But when you open up the door and the air comes in, and you kind of have to start all over again. It didn't take 46 minutes for him to die, Your Honor. And before that, they were on another call for about 42 minutes. So for an hour and a half or so, they were on the phone, but it only took him 20 minutes to die. Now, we can't speculate, what they were talking about, but I think that you can make a reasonable inference that they were talking about him dying. And then she tells her friend that he got out and was scared, and that's exactly consistent because it didn't take him 46 minutes to die. It took him 20, give or take. And we know he died, you can take a reasonable inference, he died around 7:58, 7:59 because he never answered the phone again. And 8:02, the defendant's texting Sam Boardman that she thinks he's dead. By telling him to get back in the car when he was hesitant, when he didn't want to do it, that is exactly the causation. And the medical examiner said it's suicide. She's not the final determiner of what the crime here is. You are. I remember another case, Your Honor, where a man tried to run down a victim, and the victim died of a heart attack. Well, he died of a heart attack, but it's still a homicide, Your Honor. So the fact that the medical examiner says it's suicide doesn't mean that you don't have the final say here. Her actions were the very definition of wanton and reckless, and she did in fact cause his death by telling him to get back in that car when he didn't want to die. The Commonwealth put in that video that counsel talked about, Your Honor, and I think the video shows...
Video of Mr. Roy.
Exactly, I'm sorry. The video of Mr. Roy shows exactly who he was. He was conflicted. He was conflicted, but he was trying to talk himself into accepting who he was as a person. Saying, there are good things about me, I'll have a future. And that's what he wanted, was for Michelle to accept him as a person, and she used that to get him to kill himself. So I respectfully suggest the Commonwealth has met its burden on the crime of manslaughter. I would suggest to you this is not protected speech. On the issue of the youthful offender, Your Honor, I would suggest to you, one, it's not unconstitutionally vague. I believe that was the argument. I would respectfully suggest convincing someone to kill themselves is an infliction of bodily injury. And on the issue that was not raised at the SJC, and I believe essentially the SJC said you didn't raise it so you really can't argue it, was the reasonable 17-year-old standard. There isn't one, Your Honor. There isn't a reasonable 17-year-old standard, but we're dealing with a statute that's subjective and objective. So you're using her as part of your analysis in the statute. In addition, Your Honor, the court has, at this point, the SJC has talked about juveniles committing murder only and suggested at grand jury or during trial they would have the right to, or if the Commonwealth presents a grand jury, we have to put in any sort of favorable information about the juvenile that we know on a murder case. If it's not charged with murder, it's never been extended to anything other than murder, and there's been no layout of what a reasonable 17-year-old would be. And because there is also a subjective element in this statute, I would ask Your Honor not to consider that. So for all the reasons I've stated, I believe I've tried to address all of the issues. I ask that you deny the motion.
Thank you very much.
Thank you.
All right, as I indicated to the parties yesterday, I'm going to now take a recess, and I did spend a considerable period of time yesterday reviewing the exhibit, so I'm a little bit ahead of the ball on that issue. I'm going to look at the exhibits that I need to look at, and as it relates to this particular issue, the issues raised in the argument, I'm going to look at the argument, and we will resume at 11 a.m., and I I will announce my decision at that time unless I decide that I need additional time, at which time I'll come out on the bench and tell you that. All right, thank you very much.
Please, no talking while court's in session. Please silence cell phones and place them away.
Are we back on the record, Madam Clerk?
We are, Your Honor. We're back on the record.
All right, the court has now considered the written and oral argument of defense counsel, argument of the Commonwealth, the evidence presented by the Commonwealth in its case in chief, and the law relative to those issues raised in the motion for a directed verdict, and now denies the motion for a request for a directed verdict both as to the indictment charging involuntary manslaughter and the companion indictment of the youthful offender status. All right, Mr. Cataldo, that means, are you set to proceed, sir?
I am, Your Honor.
All right.
Your Honor. Your Honor, yesterday, if it wasn't yesterday, the day before, I filed a motion in limine to introduce Facebook messages between Conrad Roy and Michelle Potter.
Okay, I didn't, yeah, so I didn't see that yesterday.
No, we
talk
didn't,
about
we
it.
didn't, we didn't argue. I
Okay.
had filed.
All right, okay. Let me see.
And figured in case I needed.
Is there an objection to this motion?
No objection, Your Honor.
Have you got the same kind of disc as, oh, you got them all printed out?
Yeah, I have them printed out, Your Honor.
Is there any question as to the authenticity of these documents?
No, Your Honor. Not, as long as it's the same ones I saw a few days ago, no problem, Your Honor.
All right, and they be admitted as, I suppose we should start with defendants. How would you like to do it? You want to do a defendants exhibit 1, or do you wish to keep
Up
them
to you,
all?
Your Honor. Do what you can do.
If I may, there are a number of exhibits already in the sequential order that the defense has presented.
All right, so we'll keep them rolling in sequential numbers unless there's a problem with that on either side?
Absolutely not, Your
All
Honor.
right, okay, thank you, let's do that then.
It'll be number 32, Your Honor.
And next, Your Honor, I would like to move to introduce, the motion had been previously allowed by this court, the so-called Dwyer records. And at this point, I have a box of made a full set of copies of what the court had previously seen highlighted copies that I had submitted to the court. I have made the redaction. You had asked that there be a redaction on one of them. That redaction has now been made on those, and these are the unhighlighted copies, and would be asking to moving them into evidence at this time.
All right, as I recall, there are a series of them, correct?
Yeah, I have them all
All right,
packaged up.
have they been pre-marked?
No, they have not been pre-marked.
All right, then,
I just want to, I don't know if you need to go to them individually.
well,
or
I think it should be on the record which exhibit number is ascribed to each of the successive exhibits. So, is there an objection to any of these exhibits?
Based on the court's previous ruling, no, Your Honor.
All right, fine, thank you. And of course, they are governed by any motions in limine that were acted on. Fine.
And-
All right, can you just list them off, Mr. Cataldo, so that we have the record complete?
Yes. Would you like me to approach individually or just put them back in the box afterwards?
You can put them back in the box and leave them with the clerk, and then I will.
The records of Alana Burke.
All right, that'll be 34? 3, okay, thank you.
Yes.
You don't need to bring, oh, I guess we gotta mark them, yeah, I guess you do that. Okay, thank you.
The next one would be Toby Hospital records. James Pearson records.
35.
Bournemouth Hospital number 1 records.
36.
Bournemouth Hospital number 2 records.
37.
Stepping Stone records.
38.
Dr. Nada, N-A-D-A, Sacknow.
39.
Dr. Jonathan Schwartz.
40,
Dr. Paul Fulton,
41,
Dr. Gullner Brule,
42,
Arbor Fuller, hospital records,
43,
St. Luke hospital records,
44,
Boston Children's Hospital records.
45,
That concludes that. Excuse me one moment. Additionally, Your Honor, what I would request of the court is, in terms of the prior motions, I had already submitted to court highlighted copies. I would ask that that be used as my chalk, the defense's chalk.
You gave them as part of the trial or in one of the?
No, the motions
proceedings?
that you had previously ruled on, they were
All right, I
highlighted.
still have those, so
Yes,
that's fine.
I'd be asking that those be the chalk.
All right, do you have a problem with that, Ms. Rayburn?
No, Your Honor, I was actually just gonna ask that these exhibits be impounded, please.
Is there an objection to them being impounded?
Yes, there is, Your Honor.
I'll give you a sidebar.
At this time, the defense would call Officer Justin King.
All right. Do you need me to act on this motion before you start with your witness testimony?
And my apology, what motion is the court holding? The
Oh, the Facebook, that was agreed to, I'm sorry.
That is, Your Honor,
All
thank
right,
you.
okay. Morning, sir.
Morning.
You may swear the witness, please.
Please raise your right hand. Swear to follow the course of testimony you will give to be the truth, the whole truth, and nothing but the truth, so help you.
Yes.
Thank you.
Good morning, please take a seat, and when you are settled and comfortable, officer, and directing your comments into that flat microphone, please state your full name and spell your last name for the record.
My name is Justin King.
You gotta talk much louder than that.
My name is Justin King. Last name is King.
All right, you may proceed.
Thank you. And where are you employed?
Mattapoisett Police Department.
And what is your duties at Mattapoisett?
I'm a patrolman.
And how long have you been employed there?
22 years.
And were you, how long, has it been 22 years at the one department?
Yes, sir.
Okay. And were you employed by them back in 2014, specifically February 19th?
Yes, I was.
And did you have some interaction with a Conrad Roy Jr.?
Yes, I did.
And could you please describe that?
Objection.
Overruled.
I responded to an assault call, sir.
Okay. And what did you do when you arrived?
What was the date, sir, again?
It was 2/19 of 2014.
Okay.
And what did you do when you arrived?
We attempted to find the victim.
Okay. And where did you?
Term victim, Your Honor.
That's, yes, officer, please refrain from using the word victim in your testimony.
Okay.
I realize that it's a common parlance, but to the extent you can avoid it, please do so.
Yes, sir.
And who are you trying to find?
We attempted to find the person that had been assaulted.
Okay. And at some point in time, did you come into the physical presence of Conrad Roy III?
I did.
Okay. And did you make any observations of him?
Yes, his face was swollen, red, and he had some lacerations to his face.
And did you take photographs of those?
I did.
May I approach, Your Honor?
You may?
May I approach? Officer, I'd ask you to take a look at those. And do you know what those are?
Yes, these are the pictures I took
Of,
of Conrad Roy III.
and a fair and accurate depiction of what you saw? All
Yes, they are.
right, at this time, I'd ask that they be marked, Your Honor.
Is there an objection?
Yes, Your Honor.
Relevance to photographs that happened in February of 2014 in a case that now is date of offense being July of 2014.
As to that issue, Mr. Cataldo?
Goes to the domestic violence, Your Honor, that
I haven't heard any evidence it was domestic violence.
you have, well, you have, Your Honor, I would
Not
say,
through this witness.
not through this,
Witnesses testify he has come to this location, looked for Mr. Conrad Roy III as a person who may have been involved in an assault incident. That's all I've heard. I've heard nothing of domestic violence. So at this point, until you establish a further foundation, the objection is sustained.
Thank you, Your Honor.
and did you investigate, when you arrived, did you investigate what had happened?
Yes, myself and 2 other officers.
Okay, and did you ever speak to a Conrad Roy Senior, or the father of the person who took the
I did
picture?
not. Officer Tavares did, sir.
And during the time that you were there, where did Mr. Roy, in the pictures, get placed? Where did he go?
He was
Which Mr. Roy?
I'm sorry, the Conrad Roy III.
Conrad Roy III. When I took those pictures, was in the back of the ambulance on Pleasant View.
Okay. And did you ever come into that evening to see Conrad Roy Jr., or Conrad Roy III's father?
I did not. Officer Tavares spoke with Conrad Roy Jr.
Okay. But did you actually at some point that evening see Conrad Roy's father?
Yes, I did.
Okay, and where was he?
He was at the Mattapoisett Police Station.
And was he under arrest?
Yes, he was.
Did you place him under arrest?
No, I did not.
The objection is sustained. Answer is stricken.
Do you know whether or not he was charged with,
Objection.
Sustained.
Your Honor, may I be heard on this issue?
Yes?
Your Honor, if the court is to, my sister was objecting, saying that this isn't domestic violence, the records, well, maybe we ought to go sidebar on this, Your Honor.
Come on up.
At this time, I'd be asked that those photographs be marked for identification purposes.
All right, they may be so marked, and I think we may have had a couple of letters already for identification, is that right?
You did, Judge.
Okay, so whatever the next letter is for the
It should be for ID from the seat.
Your Honor, additionally, I know we spoke at sidebar about a statement that I was trying to introduce. May I have that marked for identification purposes?
You may as well.
May I approach Madam Clerk?
Yes, of course. That'll be the next letter for identification, please.
One moment, please. And just to match that up, did you, when you were present with Conrad Roy III, did you obtain a written statement from him?
I did, yes.
Okay. And may I show what's been marked for identification purposes to this witness?
Yes, you may.
Okay. Ask you to take a peek at that written statement. And is that the written statement that you obtained from Conrad Roy III?
It is.
Okay. Your Honor, I'd asked it to be introduced as an exhibit, but understand your ruling.
All right, so if the record is clear here in the open court, the objection of the Commonwealth is sustained at this point in time.
Okay.
Subject to further revisiting depending on how things unfold.
Okay. Thank you.
Thank you. So that'll remain marked as an identification exhibit, an identification document.
Nothing further, just
All right, you wish to inquire this
No
officer?
questions, Your Honor.
Officer, thank you very much for
Thank
your
you, sir.
assistance in this case. You're free to go, sir.
Thank you.
Does the defendant have a further witness, Mr. McCoy?
Yes, Officer Andrew Quintin.
Morning, officer.
Good morning, sir.
Please raise your right hand. This matter before the court, swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Just take a seat up, so make yourself nice and comfortable, speak into that flat mic in front of you.
Okay.
Nice and loud, and tell us your full name and spell your last name for the record.
Full name is Andrew Philip Quintin. Last name is Quintin.
Q-U-I,
Ntin.
all right. Thank you. You may proceed, Mr. Cataldo.
Thank you. Officer Quintin, where are you employed?
Fairhaven Police Department.
And how long have you been employed there?
It'll be 4 years in September.
And what is your rank?
Patrolman.
And were you employed there at that department back on July 12th and July 13th of 2014?
Yes, sir.
In directing your attention to July 12th of 2014, were you on duty at some point?
Yes, sir.
And during the evening hours, were you on duty?
Yes.
And can you tell the court what you did in relation to a Kmart Plaza?
I was dispatched to a medical call inside of Kmart.
And what time did you get dispatched there, approximately?
I believe it was, sheet said 1640, was it?
Would anything help refresh your memory as to what time you...
I don't remember the exact time, sir.
May I approach, Your Honor?
You may.
According to,
I'm asking just if you...
Refresh your memory
Oh,
as to
yeah,
the time
yes,
you
sir.
responded.
yes, sir.
For my purposes, did you respond to a call of someone inside the Kmart school?
Yes, sir.
Okay, and at what time was that? Does your memory refresh?
Yes, sir.
What time was it?
It was at 1852 hours, sir.
Okay, thank you.
In 1852 is standard time, that would be what,
6:52.
And what time did you leave the Kmart Plaza?
6:56
And how did you arrive there?
by my marked unit.
Okay, and do you recall whether or not you had your lights flashing when you arrived at the lot?
I do not recall.
And do you know where you came from?
I came from Washington Street,
And is there anything in particular on Washington Street?
the police station.
Okay, and were you coming from the station?
Yes, I believe so.
And which entrance to the lot did you pull in?
The Washington Street entrance.
And may I see the exhibit, the blow-up?
Those right there, those two.
If you can take a look at this and just to describe for his honor, which way you came in.
I came
Judge,
from
if
this
we could
way.
just have the podium used, because we can't see.
Yes, of course. Can you bring that over, Mr. Cataldo, and maybe put like at the end of the first row, the jury box or something at an angle?
Down here, up here.
Yeah, down there is probably pretty good. Wherever is convenient, that's good. All right. And officer, you need to step off the witness stand to testify. Just keep your voice up so we make sure we get it on the record.
Yes, sir.
Can you see that, or you want to
No,
turn it?
the angle.
Can you turn it a little bit, please?
That's good. Perfect, thank you.
Not that much. That's good, thank you.
It's gonna be hard to see around me anyway, so I'm sorry.
And can you point out and show the court where you pulled in?
Which is Washington Street.
Maybe can you stand over on this side?
Yeah, that's better, that's better, thank you, sir.
I came on Washington Street this way. Entered the parking lot here. This is the entrance where Citizens Bank is located.
That's the Citizens Bank there, right there.
Yes, sir.
Okay,
Came down this way. Went past the medians. I saw the ambulance was parked basically right where there's appears to be a school bus in the photo, directly in front of the entrance. I came down about here. Came down and pulled behind the ambulance.
And you were in a marked cruiser?
Yes, sir.
And when you saw the ambulance, can you describe the ambulance?
The doors were shut and they had the red flashes on.
Okay, so the flashes were all going on the ambulance?
Yes, sir.
Okay, and what time were you dispatched to go for a medical emergency?
The time was 6:56, we just discussed.
Okay, and the ambulance arrived before you did?
Yes.
We can commit to doing this. And when you were there, did you get out of your cruiser and go into the store yourself?
No, sir.
Okay. And did you get out of your cruiser at all?
No, sir.
Okay. And so you stayed parked out in the parking lot for how long? 4 or 5 minutes?
I arrived, I saw that they had already been inside, and I left.
Okay. And did you left by going the same way you pulled in?
No, I went,
You can return to the,
okay. Just pulled out, I went across the front of Staples, Hungry Heroes, the entrance here, entrance exit here, where All Row Extension is, and I came up All Row Extension to Holliston Ave.
And do you recall where you went from there?
Just patrolling.
Okay. You can return to the seat. And do you recall on that particular time when you pulled into the lot what the conditions were like in the lot?
Weather-wise, or?
No, in terms of pedestrian foot traffic, automobiles, was the store open?
The store was open. There was a good amount of vehicles in the parking lot.
In terms of the level of activity?
Well, for Kmart, yes, it was busy.
Okay. And were there people walking around in the parking lot that you observed?
I couldn't tell you. I don't remember that.
The store was open?
Yes.
And did you see any vehicles moving within the parking lot when you were there?
Yes.
Okay. Nothing further, Your Honor.
thank you very much. Lynn? Okay.
Good morning, officer.
Go on, man.
So essentially you were there for 4 minutes, correct?
Yes.
And you're there, you're dispatched to go because there's an ambulance call for an emergency. Someone's having trouble breathing, is that right?
That's correct.
And so your attention is not to be scanning the parking lot. Your attention is to go to that Kmart to help with an ambulance that's aiding a person that's having trouble breathing. Is that true?
That's correct.
And you indicated that you drove in the entrance and came directly to the front of Kmart. Is that true?
That's correct.
And you weren't over in the west side where there's a garden area, were you, sir?
No, I was
At no
not.
point were you over in that area, were you, sir?
No, I was not.
And when you left the area, after 4 minutes, you left out and you drove away from where the garden area is, out this way. Is that true?
That's correct.
And you indicated that the Kmart was busy that particular Saturday evening. Is that true?
That's correct.
And there are many other stores in that facility or that area of the parking lot. For instance, Sullivan Tire.
Sullivan Tires. Jeez. I'm sorry. Sullivan Tires up towards the top where the Citizens Bank is.
Okay.
But connected to
Up here?
Kmart, yes.
Okay.
But
Is
connect.
the bank right here?
Yes.
Okay.
But connected to
Staples over here?
Kmart, there's a Staples in between. There's also a dollar store.
Okay. And so there's a lot of businesses in that area, and on a Saturday evening, in your experience as being a Fairhaven officer, this is a very busy area.
Yes.
And at no point did you know that there was a black truck that was missing at that time, was there, sir?
No. I was
And
not
at no
aware.
point were you looking for a car that you didn't know was missing, were you?
No, it was not.
Nothing further.
Anything? Officer, thank you very much for your assistance in this case. You are free to go, sir. All right. Do you have a further witness?
Yes, Stephen Verino.
Morning, sir.
Please raise your right hand. This matter before the court, swear testimony about to give to be the truth and the truth and nothing but the truth, so help you God.
I do.
Please take a seat and keep your voice up nice and loud. Direct your comments into that flat mic in front of you. And when settled and comfortable, please state your full name, spell your last name for the record.
Thank you, Your Honor. Stephen Verino, last name V as in Victor, E-R-R-O-N-N-E-A-U.
All right, Mr. Cataldo, you may proceed.
Thank you, Mr. Verino. Could you explain your educational background, please?
I graduated the University of Massachusetts in Dartmouth with a Bachelor of Science degree. Since then, I've taken many forensic courses and certification classes. I've attended the Paraben...
Can you explain those, please?
Sure. I've attended the Access Data User Conference, where I've learned about smartphone technology, cell phone forensics, and application data. I've then attended the Paraben Mobile Fast Track course, where I was certified as a mobile or cellular forensic examiner. I've also attended the SANS Institute for Windows Forensics, where I was later certified as a Windows forensic examiner, or a computer forensic examiner.
And are you currently employed?
I am.
And how are you employed?
I work at MWV Multimedia Forensic Investigative Services out of New Bedford, Mass.
And what is your occupation?
I'm the president of the company as well as a digital forensic analyst.
And do you have any employees?
I have one other full-time employee, yes.
And how long have you had your own business?
I've been there for over 4 years now.
Okay. And in connection with this matter of Commonwealth v. Carter, at some point did you become engaged?
Yes.
Yeah. And as a result of that, what did you do?
I was able to process electronic evidence. There was computers and cell phones that I obtained.
And where did you obtain those from?
I obtained forensic copies of the evidence from the Massachusetts State Police.
And what items specifically did you examine?
I obtained evidence of a MacBook laptop belonging to Mr. Roy, a Dell laptop belonging to Mr. Roy, another Apple desktop belonging to Mr. Roy, an Apple iPhone 5 belonging to Mr. Roy, and an LG mobile device belonging to Ms. Carter.
And can you just explain to the court how it is that you extracted information from those devices?
There's different ways we can extract data. If we have the mobile device in our custody, we utilize our forensic tools to extract data, or if it's a computer, we create forensic images. In this case, many of the items were already forensically copied by the state police, so I obtained copies of the forensic image.
And as to the MacBook and Dell of Conrad, did you do any analysis on those two particular computers?
I did. Once I received the forensic image or copy of those computer systems, I utilized our forensic software, Internet Evidence Finder, or we call it IEF, to process the data that is contained on that computer system.
And what does that software do?
The software pulls certain artifacts from the computer system, such as web history, images, pictures. Sometimes it pulls some chat history, things of that nature.
And did you find anything of interest?
I did find items on the MacBook laptop, yes I did.
And what did you do with those items?
I exported certain items from that computer system into a PDF report.
And can you explain that process and what a PDF report is?
Sure. Within the software, I'm able to bookmark or flag certain items that I find of interest. And then within the software, I'm able to print or export a report. PDF would be an electronic copy of that report, which you can then put on a CD or print out in hard copy.
And relative to, there's something called a Safari search history?
That is correct.
And what is that?
Safari search history would be the browser history on the computer system when someone's accessing, or the user behind the computer is accessing the internet. The websites or web history that they viewed is obtainable through our forensic software, and I created a report of that.
And when you say you completed a report for that, what did you do to create that report?
I bookmarked or flagged certain items through the history on that computer system. Once the bookmarks were completed, I exported those items into a PDF report.
Bookmark.
Yes.
May I approach, Your Honor?
I think Ms. Raven wanted to look at it.
Oh, I'm sorry.
Thank you.
You may.
And ask you to take a look at that and tell me what that is.
This is the report I exported from the MacBook Pro laptop that I analyzed with Internet Evidence Finder for the Safari history, sorry.
What's that?
For the Safari history.
With the Safari history, okay. And this was taken off of whose device?
This belonged to Mr. Roy.
Okay. Your Honor, at this time I'd ask that we go into evidence.
there an objection?
Which computer, Mr. Royce, so I'm clear?
The MacBook laptop.
Thank you. No objection, Your Honor.
We may be marked as the next two.
Number 46, Your Honor.
That is
You
not
can be
subject to the impound law.
And concerning what is on, is that impounded, you say, Your Honor? Did you say that was impounded?
Actually, it was not
Oh,
subject to the impound law.
Okay, I just want to make, okay, before I approach the document finder. All right, it's rejected. So I ask you, did you do anything in particular with the documents that just went in as an exhibit? Did you pull out certain illustrations?
Yes, I did.
Okay. And ask you to explain the different columns. See that? I'll do it one at a time. Can you explain to the court where it says URL? What does that mean?
The URL would be the website that was accessed by the user.
And when you say the website, the actual, who creates the website address?
The creator of the domain or the website itself. That would be, the URL would be if someone or a user went to www.google.com, that would be the URL.
And what does the title tell you, where it says title?
The title would be the title of the web page. Again, as a reference, if someone went to google.com, the title of that website would be, the title of that web page would be Google.
And the last visited date and time?
That would be the date and time that the website was accessed by the user of the computer system.
Okay. And over where it says source?
The source is telling us where the evidence or artifact was found within the computer.
And the unallocated clusters, what does that mean?
The unallocated clusters or space on a computer system is the deleted portion of the hard drive. So these artifacts were extracted or carved out of deleted space with our software.
And now when you say, how do you arrive at a particular page, a URL? How is it that a user actually gets to that page?
There are different ways a user can get to a page on the website. They can either enter the URL directly into the browser, or they can use a search engine such as Google to search a term and then access a website.
So for instance, on June 24th of 2014, this device would have accessed a particular website. Is that what you see?
Yes, sir.
And that's what your analysis shows you?
Yes.
And did this device access other websites on the 24th?
I believe it did, yes.
And what I'm showing you is in your complete book, the exhibit that we have passed into the court.
It
that
is,
correct?
yes.
You know, I have about 10 of these I'd like to publish. Just for them.
Give you a little attitude to the again, and I'll go to the same standard as Commonwealth and read it all. But I'll give you a little attitude. Can I ask a question, Mr. Verno?
Yes.
Under the column that says title, is that the name ascribed to the website, or is it the, I'm not really highly technologically sophisticated, but is that what you would type into the Google question mark?
These particular websites are just showing the URL access, so that would be the title of the web page itself.
All right, thank you very much.
Yes,
You
Your Honor.
did, on that point, you did do another analysis of actual type-in search queries, is that correct?
I did, sir.
again, as I'm showing these to the court, these are the included in the book that I passed into the court.
That is correct.
And approximately how many different queries did you, not queries, but titles did you put in the book? Approximately.
I believe on the bottom of the page will tell you a page number on the bottom right.
Okay.
All right, Mr. Costello, let's move on. If you have a specific question.
All right, thank you. And next, Mr. Verino, did you go through the MacBook for parse search queries?
I did.
And what are parse search queries?
The parse search queries would be the search terms that were entered into a search engine such as Google or Bing.
So that's basically what I just asked.
Yes, Your Honor.
Okay.
Yes.
On some of these various books, that you also created not just the documents, but there's a disk within, and that's just the digital copy of what is contained, the documents next to it.
That is correct. There's a CD in every binder that is the digital copy of the hard.
No objection, Your Honor.
All right, maybe marked as the next exhibit, not subject to impoundment.
Number 47, Your Honor.
And Mr. Verneau, did you do anything relative to the Dell computer that you analyzed?
I did. The Dell computer, I utilized the same forensic software, Internet Evidence Finder, and was able to review artifacts on that computer system as well.
And is there something known as a Skype chat?
Yes, there is.
What is a Skype chat?
Skype is an application that can be accessed on a computer system. It can be used to web chat with the camera on a computer system, or you can also type or message other users. Within our software, we're able to extract the Skype chat messages from a computer system.
And were you able to do that to Conrad Roy's Dell computer?
Yes, I did find Skype chats on the computer system.
Okay, and what did you do with, is there anything you did after reviewing Skype chats?
After reviewing the Skype chats, I exported a few of them into a PDF report.
Okay.
A few of them, did you say?
Yes, not the entirety.
What was the basis of your selection process?
There was some Skype chats within the computer system that I found relevant, that I thought would be relevant to this matter, from the content.
And when you say the content, what was the content that made you think it was relevant?
The messages back and forth with the other user from the computer system.
And what was the subject matter?
If I could review.
Okay.
Again.
May I approach?
You may.
I found messages on here that pertain to the author or the user within Skype, and the user is speaking about his feelings and how he feels.
About suicide?
Yes.
Okay. Your Honor, I asked that that be marked as an exhibit.
Is there any objection?
There isn't, Your Honor.
It'll be marked.
Now, Mr. Verneau, concerning Conrad Roy's iPhone,
Yes,
did you analyze that?
I did.
Okay. And what is a timeline report?
A timeline report, when we utilize our forensic software, in this case we utilize Celebrite Physical Analyzer, which is able to open or view the forensic image of this cell phone. The timeline report is a chronological order of all communications located on the device.
And what did you do relative to his timeline report?
For his timeline report, I exported a PDF or printout of that report.
May I approach, Your Honor?
May?
In terms of the timeline, are there photographs, videos, or is it just text?
The timeline report that I exported is just communications, which would be text messages, MMS messages, call logs, and things of that nature.
Okay. May I approach, Your Honor?
You may?
What,
It's,
can you explain to the court exactly what is on this?
it would be text messages, multimedia messages, chats, instant messages,
Okay, text messages, what was the next thing?
multimedia messages.
Okay, what is that?
It could be a picture message or a video message. Instant messages or chats, which can be any communication via Facebook, things like, or other third-party applications. If there's Snapchat messages or any Facebook messages, they would be located in there as well.
And you said also a call log?
Call logs, incoming.
That's actually an old-fashioned phone call, right?
Yes, incoming
Okay.
phone calls, yes.
May I approach?
Yes.
Yes, you identify that.
Yes, it's on a CD. That would be the timeline report from Mr. Roy's iPhone.
Okay, at this time I'd move that be introduced in
Is there an
evidence.
objection?
Based on the representation of what's on it, no objection, Your
All
Honor.
right,
Thank
you
you.
mark with the next exhibit.
Now, Mr. Verino, in terms of Conrad Roy's iPhone, sticking with that for a minute, is there something called Notes?
Yes, on an Apple or iPhone device, there's an application called Note or Notes. This allows the user to type in whatever they would like, just like a Word document on a computer system.
And did you, relative to any particular notes, did you export any notes?
I did. I exported one note as a PDF report.
Okay. May I approach?
You may.
Ask you to take a look at that, please. Tell me if that's what that is.
Yes, this is the note I created a report of from Mr. Roy's iPhone.
Okay.
Does that report reflect the date of that note?
It does, Your Honor.
All right, thank you.
At this time, it has to be marked as an
Is there
exhibit.
an objection?
No, Your Honor.
It'll be marked.
Sticking with Mr. Roy's iPhone, did you do anything relative to it in terms of images?
Yes, when I reviewed the iPhone device, there were photographs or images on the phone. Those photographs could come from website access, taking the picture from the phone, or picture messages coming into the phone can be saved. From a review of those photographs, I bookmarked a few items and exported a report of those photographs.
May I approach? Ask to identify that, please.
This is the extraction report of the images I exported of Mr. Roy's iPhone.
At this time, I'd ask that it be marked as an exhibit.
No objection.
May be marked as the next exhibit.
In sticking with Mr. Roy's iPhone images, did you do anything in terms of images sent or received, specifically narrowing that?
Yes, I located MMS or multimedia messages on the...
And again, what are those?
Multimedia messages would be a picture or video sent to another cell phone or user. I located certain items between Mr. Roy and Ms. Carter on the cellular device and exported certain multimedia messages into a PDF report.
Okay.
Thank you.
Approach. ask you to take a look at that and identify that, please.
This is the MMS report I exported from Mr. Roy's iPhone with our multimedia messages with Ms. Carter.
All right, and specifically on that one, there's a couple of pages in the front. And can you describe what the couple pages in the front are versus the larger blow-up images?
Sure. The first 3 pages are the extraction report from our forensic software. It details the device information, such as the iPhone. It then goes into show a smaller thumbnail of the image, and then it gives you the timestamp associated with the message itself. After page 3 would just be the blow-up or the larger version of that thumbnail.
And does the thumbnails, does it also have the data if it was sent to or received?
Yes, it will detail if it was to or from a certain party.
Okay. This time I'd be asked it be marked as an exhibit.
Objection? Next exhibit, please. What name is that now?
52, Judge?
I'm sorry, 52?
52.
Thank you very much.
And now, Mr. Verano, did you do anything relative to Michelle Carter's phone?
Yes, I received a forensic image of Michelle Carter's LG device, a smartphone cellular device, and I was able to review the contents of that device.
In concerning images of her phone, did you do anything relative to the images on her phone?
Yes, similar to the last exhibit, I reviewed the MMS, or multimedia messages, on that device and was able to locate certain images sent and received to Mr. Roy from Ms. Carter's cell phone.
And I'll ask him to. And again, ask you, Mr. Verano, to describe what I've just given you.
This is my extraction report of the multimedia messages from Ms. Carter's LG device.
And again, if you could just describe to the court the first couple of pages, the thumbnails versus the larger photographs.
Sure. In this binder, the first 4 pages are the device information, as well as the time the message was sent or received, as well as the thumbnail associated with that message. After page 4 is a representation, the larger image from that thumbnail.
In the first few pages, there's a guide that tells you who sent it, which phone sent it to which other phone.
That is correct. It will tell you if it was to or from a certain party.
Okay. This time I'd ask that it be marked, Your Honor.
Any objection? No. Any mark?
And did you do anything relative to any Facebook chats from the physical extraction report on Michelle Carter's iPhone?
Yes, on Michelle Carter's LG device, there was Facebook messages that I was able to locate.
And what did you do with those Facebook messages?
I was able to review some of the Facebook messages and export a report of between 2 parties, I believe.
May I approach? Ask you to identify that, please.
These are the Facebook chat messages that I exported from Ms. Carter's LG device.
Okay. Your Honor, at this time I'd be asked that that be marked as an exhibit.
No objection.
May be marked.
One moment, please, Your Honor. Now, Mr. Verno, relative to links on the, what is a link? What is a link?
A link could be like a website link, can be sent or received over a text message. You can send a website address.
And during your analysis of these various phones, did you look to see if any links were sent from Conrad Roy to Michelle Carter?
On Michelle Carter's LG device, I was able to locate a couple URLs or website links that were sent to her from Mr. Roy.
And what did you do with those?
Those two URLs, I exported the URLs into a PDF report with our software and put them into a binder.
Okay. And approach, please, ma'am.
Ask you to take a look at that, please.
This is the report I exported from Ms. Carter's LG device that contained the URLs that I located from Mr. Roy.
At this time, I'd be asked that that be marked as an exhibit, please, sir.
Maybe marked.
And now, Mr. Verno, in terms of the text messages from Conrad Roy's phone in Michelle Carter's, analyzing the LG phone now, did you do anything relative to the text and Facebook chats from that phone?
Yes, when analyzing Ms. Carter's LG device, I located many conversations with Mr. Roy. I exported all text messages and Facebook chats between Ms. Carter and Mr. Roy onto a DVD.
Did you limit that to any period of time, Mr. Verno?
It's the entirety of whatever's located on the phone.
Okay, thank you.
Yes, Your Honor.
It was the LG phone?
This is Ms. Carter's LG device.
Everything on her phone. So, got it. Okay, thank you.
And is this that disk?
Yes, yes it is.
At this time, I asked to be marked.
Just a disc would be fine. Unless you.
Yeah, no, just a desk at this time, yeah.
Okay, that's fine.
Thank you.
Hearing no objection, it will be marked as the next exhibit.
Thank you, Your Honor.
And Mr. Verno, what is a web history?
Web history is much like the Safari history I talked about previously. It's the websites that are accessed by a user on a computer system or a cell phone.
And can a web history be cleared or deleted?
Yes, yes it can.
Can you explain that whole process and if it's recoverable or if it's not recoverable?
It all depends on the particular device being used. In this case, with the Safari history, that was carved out or recovered from deleted. So in that case, the deleted content was recoverable. Depending on like mobile forensics and cellular devices such as newer iPhones, when web history is cleared, most of the times it is not recoverable.
And in terms of the LG, not the LG phone, the iPhone, Mr. Roy's iPhone, did you look to see the history on that phone?
Yes, I noted that there was no web history when I analyzed that device.
Okay, and what does that mean when there's no web history?
There was no websites accessed when I was reviewing my forensic extraction report, meaning it's possible it was cleared out.
Okay, and if it's cleared out, is it possible to retrieve that on that kind of phone?
On that particular device, we are not able to recover the web history.
On which phone now?
This is the iPhone 5.
Okay, thank you.
And the iPhone 5 belonged to?
Mr. Roy.
Okay. And next, can you tell me what, on an iPhone, did you analyze Mr. Roy's iPhone in terms of its block caller feature?
I did.
And what is a block call feature?
The block caller feature enables a user of the device to block a particular party or phone number in that phone, so it would limit or stop any communications coming in from that particular party you blocked, such as text messages or a phone call.
And did you determine if Conrad Roy had utilized that feature?
There were parties located in his block caller list, yes.
Okay. Was Michelle Carter one of those?
No, she was not.
Okay. Ask you to take a look and if you can identify this. And what am I showing you?
This is the iPhone 5 of Mr. Roy, and this is a screenshot that I was able to obtain of the blocked list from that device.
Okay, from your extraction report? Or is this just...
It's just a screenshot of the device itself. Our forensic software does not pull the block caller list, so you have to actually navigate to the list to view it.
So you physically viewed this?
Yes.
This time I asked if that be marked as an exhibit.
No objection.
Maybe Mark?
Nothing further.
Good afternoon.
Good afternoon.
So I just want to go over what you analyzed first, okay? So just so I have a clear picture of all the devices you looked at and all the information you had, okay?
Sure.
Did you receive a CD with CSLI information from counsel? Cell tower information on this case?
I did not receive a
You
CD
did not.
of it.
So you didn't do any analysis relative to cell towers?
I did not analyze cell tower information.
Great. So you went through the items that you looked at. You listed Ms. Carter's LG phone, correct?
Yes.
Conrad Roy's iPhone?
Yes.
And how many computers did you analyze relative to the Roy family?
3.
How many computers did you analyze relative to the defendant?
I have no reports from the defendants.
Okay. You know she had a computer that was seized, correct?
Yes.
And it was made available to you, wasn't it?
It was.
Okay. How come you didn't analyze it?
I didn't find anything of relevance on it.
So you looked at it?
Yes.
Okay. Madam Clerk, may I borrow the exhibits from yesterday, please? Thank you. I just need a moment, Your Honor. Oh, can I mark a list? They might tell me. May I approach the witness, Your Honor?
You may.
Thank you. Sir, I'm going to show you what's been introduced as Exhibit 29. It has 2 pages. Can you look at those, please?
Okay.
Did you find those when you analyzed the defendant's computer?
I did not find this document, no.
Okay, how about there are 2 separate documents. Did you find either one of them?
I did not.
You did not. Thank you. Well, what did you find on her computer?
I don't recall. I didn't bookmark or export any reports.
Well, what were you looking for? What type of search, strike that. Fair to say that analyzing a computer is not like analyzing a phone. You can't just attach it to Celebrite and download it, correct?
No, it's a forensic image that you have to analyze.
Right, so you have to look for things.
That's correct.
So in looking at the defendant's computer, what were you looking for?
I was looking for some web history, same things I was looking for on Mr. Roy's computer.
And you're saying you didn't find anything relevant to suicide or how to kill yourself on the defendant's computer?
From my review of what I looked at, I did not bookmark or export reports.
But you say you didn't find either of those documents, correct?
I did not locate those, no.
Fair to say you looked at them, the word suicide is in those documents multiple times?
In those documents I reviewed, yes.
Okay, but you didn't find them?
I did not.
Okay. All right, so you did look at her computer, you just didn't find anything?
I did not create reports, that's correct.
So let's talk about the iPhone. You indicated that,
The iPhone now would be that of Mr. Roy.
yeah, Mr. Roy's phone, how about I just call it that? Mr. Roy's phone, you analyzed it, correct?
That is correct.
And you just introduced a binder full of, that had pictures from Mr. Roy's phone, correct?
Yes.
And you would, fair to say, the pictures that you were introduced, you only took ones from July of 2014, correct?
I don't recall the exact dates of them.
Well, fair to say Mr. Roy had hundreds to thousands of images on his phone.
Yes, a phone contains many, many images.
Right. And you have, can I borrow that, the binder with, oh, see if I can remember which one? Thank you. Absolutely. Images. 51, please. Thank you. Okay. May I approach the witness, Your Honor?
You may.
Thank you. So, in your report, sir, you have here data files, these thumbnails, sometimes people call them JPEGs. They're smaller versions of the bigger picture.
That's correct.
Okay. And how did you pick the ones you wanted?
I found the ones that I believe to be relevant to the case.
Sorry, you found the ones,
That I believe to be relevant?
okay.
So what analysis did you use to determine whether or not you thought they were relevant?
Viewing the images, which again, there are thousands of images on the device, I just scanned through the different images and bookmarked certain ones that caught my eye.
Fair to say the ones you picked out are ominous ones from July.
There are April, May, June, July.
A lot of them from July.
Yes.
Now, what other information did you have about this case? What were you told to look for?
Objection, Your Honor.
How is that not violative of the attorney work product rule of counsel? and
Fair
ethics?
enough, Your Honor, I'll ask it a different way.
Thank you.
You would agree with me, sir, that prior to July of 2014 on Mr. Conrad's phone, mainly focusing on June, there were extremely happy photos on his phone of him and his family and positive sayings on his phone.
I don't recall every image on the device that I reviewed.
Well, how about I show you the images from June and see if you recognize them? Is that okay? Sure. If with the court's permission, of course. Thank you. The pictures that I showed you, Court. Thank you. And I'd be happy to show you the smaller version with the dates on it if that helps as well.
Okay.
You would agree with me that the photographs that I've shown you are from, actually your extraction report from June of 2014 on Mr. Conrad's phone.
These photographs appear to be an extraction report, yes.
And the photographs themselves, those are larger images from that extraction report.
I've located the first two, yes.
I tried to put them chronologically, at least starting on June 8th and working up from that.
Yes, these would be larger representations of these thumbnails.
And would you agree with me if I said those pictures from Mr. Roy's phone that were extracted from June of 2014 are pictures of him and his family looking happy? Would that be accurate of some of the pictures from June 8th, 2014?
Objection.
Sustained.
Your Honor, I would move to introduce the photographs.
Right, but a determination of whether someone looks happy is a matter
Absolutely, Your
of
Honor.
final fact.
Absolutely, then I just move to admit them, Your Honor.
Objection.
What was the question?
I would move to admit them, Your Honor, as a group.
What's the objection? They come from the same source that has already been admitted, is that correct?
Yes, they're just,
Well, why is there an objection?
Because they're a duplication of what the court already has.
I suspect that many of the documents that you introduced, Mr. Cataldo, may have been duplications of that which was presented as part of the case in chief. I will allow it.
thank you, Your Honor.
But I would note the court denied some of the photographs I tried to get in 30 minutes ago.
Duly noted.
Thank you, Your Honor. Okay. 58. Relative to Exhibit 50, you also indicated you extracted a note off of Mr. Roy's phone, is that correct?
Yes.
Could you please tell the judge what a note on someone's phone is?
A note, again, is the app or application on an Apple device, which is called Notes, and a user can enter data into that like a Word document.
And you would agree with me that when Mr. Roy's phone was extracted, there were a lot more than just one note on there?
I believe there was more than one, yes.
With the court's permission, may I approach you with a portion of the extraction relative to the notes?
You may approach the witness.
Thank you, Your Honor.
You may characterize what it is, but you may approach him.
Yes, Your Honor. Do you know what you're looking at there, sir?
It would appear to be a Notes segment.
Okay. And does the first one, number 1 there, of that note section, does that match number 1 from the sole note you put in?
Yes, it does.
Do those appear to be the note section from Mr. Roy's phone?
Yes, it does.
Just all of them, correct?
Yes.
Your Honor, I move to admit.
Objection?
No.
Mark?
All right, now, relative to the extraction reports that you put in, one for defendant's phone, one for Conrad's phone, you indicated they include MMS messages.
There are, yes, I did introduce MMS messages, yes.
Fair to say so there's a couple of different types of MMS messages. Some would be sort of a group text message.
That is correct.
Also, it could be if I send you a text but I include a photograph with a picture as an attachment.
That's correct.
That also is an MMS message.
Yes.
Now, when you put the extraction reports on the CDs for His Honor, is there a link to attach, say the MMS message is a text from me to you with a picture, can His Honor access that picture that's attached to it on the CDs you provided the court?
It would show the thumbnail of the
It'll
image.
show the thumbnail, okay. Now, with regard to the photographs that were extracted from the defendant's phone, the ones that were moved into evidence, is that all of them?
Which ones that were moved into evidence?
I'll get the exhibit to make that more clear. '52, please. If I may approach the witness, Your Honor. Showing you Exhibit 52, is this images off of Conrad Roy's phone sent to Michelle Carter and sent from Michelle Carter?
Yes, these would be MMS messages.
Is that all of them?
All the MMS? No.
And you would agree with me that what was introduced into evidence before His Honor, whether it's that exhibit or any exhibits, it did not include all of the photographs that the defendant sent to Mr. Roy, do they?
I don't believe so, no.
And I approach the witness, Your Honor.
May.
I'm going to show you 2 pictures. Do you recognize those as being attachments sent from the defendant's phone to Mr. Roy's phone on July 3rd, 2014, that accompanied text messages?
Unless this is in my exhibit, I don't recall seeing these specific photographs.
Did you open all of the MMS links?
Did I open all of the links? No, I did not.
How come?
There was over 300 links to open. I reviewed them. I don't recall seeing these images.
How many of them did you review?
I scanned and exported them into my report. I have 12 of them.
Well, if we put in the CD relative to your download of the defendant or Conrad Roy's phone, and we went to the MMS messages, would His Honor be able to find those? For July 3rd, 2014, did you include those on the CDs?
In the CDs of the full timeline reports, yes.
Okay, thank you. You indicated, sir, that in the extraction reports you included a call log, is that correct?
Yes.
As to both Mr. Roy and the defendant?
Yes.
So both of their call logs are going to be on the extraction reports that His Honor has?
Yes.
Now, relative to the images that were sent back and forth between the defendant and Mr. Roy, did you ever do an image search to see where those were generated from or where those pictures initially came from?
The MMS that was sent back and forth?
Yes.
Where they came from?
Yes.
No, I do not.
Fair to say if someone has an image on their phone and it wasn't Mr. Roy or the defendant, you could then take that image and research to see what website it came from. That's possible, correct?
Well, once the image would be sent through the mobile device, you talk researching like metadata associated
Exactly.
with the photo?
Yes.
If the photo was taken by a particular device as snapped by that mobile device, the metadata would show that was from an iPhone or an LG device in particular. Unless you just research on the open web that photograph, you might be able to find where it came from, but the photograph itself won't have the link.
Well, that's certainly doable if you have an image that is sent back and forth or on someone's phone and you want to see if neither one of them took it where it originated from, you could do a search on the web to see, hey, did this come from some third party's web page or some other website? You can do that, correct?
You can open source search nearly anything, yes.
Did you open source search any of these images?
I did not.
Just going to do one more, Mr. Clerk. Can I borrow you this one? Thank you very much. 46 and 47, please. Thank you. May I approach the witness, Your Honor?
You may.
Thank you. Starting with Exhibit 46, sir, would this be all of the web pages that you were talking about? So as His Honor asked, not what you put into search terms, but what web page you ended up at?
These are websites ended up, yes, on the computer system.
Could you please tell the court what the start date of those is?
The first item would be from February 28th, 2012.
So the website start back in 2012?
There are access, yes.
Now, just so I'm clear, Mr. Verma, that item, exhibit rather, 46 is information derived from what device?
This is the MacBook Pro laptop
Okay,
of Mr. Roy.
Okay, thank you.
So they start in 2012, correct?
That's what I have here, yes.
Thank you. And number 47, again, Mr. Roy's computer, would these be the actual terms somebody put into the computer to do a search?
The parse search queries, yes.
Thank you. And what date did those start?
The first one here would be June 19th, 2014.
From June 19th, 2014, when did they end?
The last entry would be July 10th, 2014.
And relative to the search terms or parsed search queries, whoever was accessing the computer is asking questions, correct?
Something you can do, yes.
Okay. Researching
Typing in whatever term into
over
the,
a period of several days.
yes.
And on the web pages, that starts from 2012.
That's the first one, yes.
So this is web pages that someone was asking questions about or looking at for a extended period of time, correct?
There's web history for an extended period of time, yes.
48, that's Skype, correct?
That is correct.
Okay. Could you explain what a Skype chat is, please?
Skype is a third-party application that can be found on a computer system or a cell phone, where a user can send or receive content or messages.
And that was the only relevant one you found on his computer, the only relevant Skype chat you found on any of the Roy family computers?
These are the Skype chats that I export as a PDF report, yes.
And those date all the way back to 2012?
That is correct.
Just a few more questions, Mr. Varinell. Sure. Relative to the examination of the defendant's phone, you indicated that there's an extraction from her phone, correct?
Yes.
Okay. Is that the logical extraction or the physical extraction?
What's entered, what I worked off is the physical extraction.
And fair to say that when you looked at the physical extraction of the defendant's phone, she had deleted text messages, correct?
There is deleted information, yes.
Okay, so someone had deleted messages off of her phone that you were able to recover.
A user doesn't always have to delete messages. A phone can only maintain so much memory, so sometimes messages are auto-deleted, but there was deleted content on the device.
But fair to say some of the deleted ones were the recent ones?
I
Right.
believe so, yes.
Okay, so what you said is true, correct, that your phone will sometimes delete, but it'll start with the old ones, correct?
That is correct.
Okay, so if the more recent ones were deleted off of her phone, say in July of 2014, it's unlikely that the phone deleted those, correct?
It is possible for a user to delete text messages.
Okay, right. But she had tens of thousands of text messages on her phone, correct?
There was a lot.
And they date all the way back to 2013, correct?
I believe so.
So there's no reason to believe that her phone would have started deleting the 2014 text messages, correct?
Correct.
Much more likely it was operator deletion, correct?
Yes.
And some of the ones deleted from her phone are the ones between her and Mr. Roy, correct?
There were deleted messages between the two.
Some of the more recent ones, the ones leading up to July 12, 2014, some of those were deleted off of her phone.
Some content was removed, yes.
Nothing further. Thank you, Your Honor.
Any redirect, Mr. Cataldo?
Yes. Was there an image sent of a generator on July 11th by Conrad Roy to Michelle Carter? Do you recall seeing that?
I recall seeing it. I'm not specific about the date.
Okay. May I see the image book marked as an exhibit? I think it's 52. May I approach, Your Honor?
You may.
Handing you that exhibit, were there any messages sent from Mr. Roy, multimedia messages sent on July 11th from him to her?
There are two, yes.
Okay, what are they?
There is one message sent to Ms. Carter on the 11th of July. It is a screenshot of a website about carbon monoxide. And the other one sent to Ms. Carter on July 11th is an image of a portable generator.
Nothing further.
Recross.
Thank you, Your Honor. image sent from the defendant's phone to Mr. Roy's phone, also about carbon monoxide, on the 6th.
I don't,
July 6th, sorry, July 6th.
I don't recall.
May I approach?
Me?
I don't recall seeing the specific image. If it was, it'd be in the entire timeline.
So this would be in the timeline.
That's correct.
Thank you. Nothing further.
Thank you very much. You all set, Mr. Costello?
Yes, sir. Yes.
Mr. Bruno, you may step down. Thank you for your assistance in this case, sir. You're free to go.
Thank you, Your Honor.
Costello, further witness?
Don't think an officer, Tavares, I'm not sure he's arrived yet,
All
however.
right, well, let's find out.
Oh. Oh, tell him it's Dennis. Dennis, yeah, that's Dennis. There's two Tavareses. No, we're looking for Dennis. Wrong one. Not here yet.
He has not arrived?
He's not
All
arrived.
right. Do you have any other witnesses?
No, that would be it.
Come on up for a second, please. I just want to ask you a question before we break the line. So, Mr. Costello, do you have another witness?
Well, first, Your Honor, I'd like to address, there was, at the beginning of this trial, there was a, I think it was a motion, but a stipulation to enter into evidence anchor counseling records of Michelle
Okay.
Carter. By agreement, at this time, I would ask that they go in as an exhibit.
Is that your understanding as well, counsel?
Yes, Your Honor, that's my understanding.
All right.
And Your Honor, I would make, pursuant to my earlier motion of Conrad Roy's records, the Commonwealth would also move that these records be impounded, and I will include that in my motion for impoundment on Monday.
All right. Is there an objection to holding
No.
that until we are? So, for the members of the public and the press, as you heard this morning, there are certain records that have come in that really relate to medical and mental health treatment of various individuals involved in this case. I have ordered that those be impounded now until such time as council have the opportunity to file a written motion in accordance with the rules that provide for such written motions, affidavits, and so forth. So those records will come in. The anchor records will be impounded along with the records that were introduced by Mr. Cataldo at the start of his case regarding the same areas of substance matter, and we will have a hearing on that motion if it is filed in due course. All right?
Thank you, Your Honor.
Thank you.
Your Honor, my next witness is Dennis Tavares. He's a police officer under subpoena to be here. He said he'd be here at 2 o'clock, and he still has not shown up.
Call him in the hall, please.
Apparently he's here.
He is here. All right, well, that's good. All right.
Okay.
Good afternoon, officer.
Good afternoon, Your Honor.
Please raise your right hand. This matter before the court, you swear testimony about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
All right, sir, please take a seat.
Thank you, sir.
Make yourself nice and comfortable. Address your comments loudly into that flat microphone in front of you. And when you are settled and comfortable, please state your full name and spell your last name for the record.
Dennis James Tavares, Tavares.
All right, you may proceed, Mr. Cataldo.
Thank you. Good afternoon, Officer.
Good afternoon, sir.
And, Officer, what is your occupation?
A police officer for the town of Mattapoisett.
And how long have you been so employed?
It's my 22nd year.
And is that entire time with the Mattapoisett Police
That
Department?
is correct.
And so you were employed as a Mattapoisett police officer back in the year 2014?
Correct.
And directing your attention to February 19th of 2014, were you employed?
Yes, sir.
And did you have some opportunity at that point in time to deal with a Conrad Roy III and Conrad Roy II?
Correct.
Okay, and can you tell the court about that?
Well, why don't you tell us, let's make it a little more specific
Okay.
than that broad question, Mr. Cataldo.
It's, okay. Do you recall what shift you were working on that particular
I was
night?
working the 4 to 12 shift, sir.
Okay. And at some point in time, were you dispatched to a particular location?
Yes.
And where was that?
I was dispatched to 7 Highland View Ave for a reported assault victim.
Okay, and what did you do as a result of that dispatch?
Myself and 2 other units responded to the area to search for the victim. I was unsuccessful.
Please, officer, refrain, and I know it's difficult, but please refrain for use of the word victim in your testimony.
I apologize, Your Honor.
That's the subject of a prior motion allowed
Correct.
by this court.
As a result of that dispatch, what did you do?
I found myself at a home located on Perkins Lane.
And what did you do when you arrived at that
I
location?
interviewed an older male and a female.
Okay, and do you remember the older male's name?
Conrad Roy,
And did you speak with any other individuals?
his girlfriend.
And during that time, what other officers were at the
I
scene?
believe I was working that shift with Officer Justin King and Officer Robert Randall.
And did you make any particular observations when you were there at the household?
Yes, I did.
And what observations did you make?
I observed some abrasions and some dried blood on the face of Mr. Roy.
And did you ask him specifically what happened?
Yes, I did.
And what did he tell you?
Objection.
All right, first of all, and I know, officer, that it has nothing to do with you, but there are apparently 3 Conrad Roys whose names have come through this whole process.
Correct.
So the individual upon whom you made these observations, you made these observations of the abrasions, was that,
I'll identify him as the father.
that was the father?
Correct.
So, all right, okay. So that was Conrad Roy II, right?
Yes.
Okay. Now, there is an objection. The objection is sustained.
And how long did you speak with this individual?
I spoke with the father approximately 15, 20 minutes maybe,
Okay. And how long were you at the scene?
maybe 30 minutes.
And did you speak to any other individuals?
I did.
And what other individuals did you speak
I
to?
spoke to a female party, I believe her last name was McGonigal.
Okay. Did you speak to anyone else?
Not that I recall.
Okay. And at the end of the time that you were there, what did you do?
Before concluding my investigation, a male party was subsequently placed under arrest.
And who was that male party that
The
was
father.
put? The one you
Mr.
were speaking to?
Correct.
And what was he arrested for?
Assault and battery domestic.
And who was the subject of that?
Objection.
Sustained.
Were photographs taken of the particular person who was involved with Conrad Roy, the father?
Yes.
May I approach, Your Honor?
You may.
May I see what's been marked for identification purposes? Yeah, today, I'm sorry. Today. Ask you to take a look at those photographs. And can you say what those photographs are?
Yes, sir, that was a subject that was allegedly assaulted.
Okay. At this time, Your Honor, I would move to introduce those photographs.
Objection.
I'll hear you.
Same objection I put on the record before, Your Honor, that those were taken on about February 19th of 2014, some 4.5 months prior to the date of the incident that we're here for, and at this point, those photographs have no relevance to this particular matter before the court.
Your objection is overruled. I will allow them to be admitted and give them such weight given the time frame as I feel appropriate.
Thank you, Your Honor.
Nothing further, Your Honor.
All right?
No question.
Officer, thank you very much. You're free to go.
Thank you, sir.
Do you have a further witness?
No, we do not, Your Honor. So, subject to what I mentioned yesterday about Dr.
Oh, yeah.
Reagan, the expert.
Yes. May I see the counsel side? At an earlier sidebar conference with the attorneys, the court had indicated that some latitude would be given to the defense to get their expert here who lives out of state. And apparently that is the next witness who will testify. And so consequently, we will now suspend these proceedings until Monday morning at 9 a.m. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.